morning. This is a topic which has created generated a lot of interest and a lot of questions over the last few years. So we thought we would revisit it, and it also is quite relevant today, just given from the amount of questions that we already have even before we've started on the issue of absenteeism and how to manage. I'm joined here by my colleagues Michael Horvat and Megan Cowan. We're going to take you through. We have a full agenda, so we're going to take you through this and leave some time for questions as we get there. So thanks again for joining. I want to remind you of a couple things. We will have another webinar, and I'll remind you this at the end of the piece on Tuesday, April 16th on the modern workplace managing to succeed. And then at the end, there's a little link you can hit for the 2019 Canadian Occupational Safety Reader's Choice Awards. We've been nominated, and we want you to vote for us. So let's get into this right away. Here's our agenda: managing, accommodating, drafting, and a case law update. The case law is always new and exciting in this area, but we're going to go over some principles, and it will help you understand how the principles of absenteeism are implemented into case law and how to avoid it or how to manage it. So absenteeism in Canada. These are 2015 numbers, and they're as recent as we can get in many cases, but they are compiling them. And you can see what the rates are per full-time employee. I suspect that's a lot higher right now, particularly given the last couple of years with a focus on bullying, harassment, mental health, the ability to take time off and get yourself better. Higher for unionized workers because it's more difficult to terminate them. I said that. But that's compared to 7 days for non-unionized employees. People under collective agreements generally have higher rates of absenteeism. We're starting to see, and this is a topic in our next webinar, parents of younger children and older employees and female employees had higher absenteeism rates than the general population. And in the last decade, mental health claims have increased by 3%. And that is in part due to an awareness of mental health and managing and employer initiatives with respect to mental health in the workplace. So what does that cost an employer? Well, there are the direct costs, and that is replacement costs of bringing other people in, benefit costs that arise from benefit coverage to employees, sick days, and the like. The administration costs, which are related to simply administering people who are off work, dealing with them, and that's a time issue as well. And additional costs that may come from group insurance programs that may have additional coverage as well. The indirect costs we've seen in the past have been a reduction in morale and reduction in productivity. The morale issue is an interesting one because it's a two-edged sword. On the one hand, you have individuals who say, if you're sick, you shouldn't come into work. On the other hand, you have employees who remain at work saying, I'm now in a position where I have to do more of the work as a result of people being off work. So those are the direct and indirect costs of absenteeism, which you probably all see on a day-to-day basis. But we are both users of the absenteeism system when we get sick, and we are also critics of the absenteeism system when other people get sick. So this is really creating a balance. How do we manage? And we're going to get into this, particularly because the biggest thing that we as lawyers find and the biggest point of confusion and is reflected in many absenteeism policies is the difference between two different types of absenteeism, culpable and non-culpable. They're both treated differently. We may end up with the same result in the event that we're trying to get a person back to doing their essential duties, but culpable is blameworthy attendance issues. Non-culpable or innocent absenteeism, as they use in the unionized context, is when there is nothing that the employee can do. It's a result of an illness, for example. So Michael's going to start taking us through that. Michael?
Thank you, Lorenzo. So for culpable absenteeism, we're talking about blameworthy, people who've done something wrong. So, for example, people who are absent without a reasonable excuse. This is the alarm didn't go off, my ride didn't pick me up on time, I was late for the bus. These are all things that with reasonable planning, individuals could get to work on time, but don't get to work on time and use as an excuse that clearly can be foreseen. Absence without leave. This is absence where they do have a reason for the absence, but they don't tell you. They don't give you information. So they're holding back. And in that context, they have to provide support for the reason. You are entitled to ask Continuing today, even now under the ESA and the changes which were not changed under the ESA, you are allowed to ask for information relating to the reason for their absence. Out and out lateness, this is just people who don't make it to work on time. And even if you've got a reason and you've got support, if you don't call and you don't show, if you don't follow the process set out in your policy, again, that's culpable. The person may actually be sick, may actually have the flu, but if they don't give you reasonable advance notice of that and follow through on the process, they can be held to account in respect of progressive discipline. And then, of course, abuse of emergency leave. So these are just people taking off without actually providing any reason and support. Other issues of culpable absenteeism can include reporting for an unfit condition. Now, this, of course, raises the issue of accommodation for potential disability issues. That is, if the person shows up to work drunk, to what extent is that an issue of disability, or is that one in which the individual could have avoided it and therefore should not even have shown up for work? Leaving work without permission, even in emergency circumstances, cell phones, texts, it doesn't take much to tell your supervisor or your manager that you're leaving. Pattern absences, this is a big one. This one is one in which requires management to do some due diligence. That's actually tracking where individuals are going off. And if it seems that they're always off on a Monday or a Friday in advance of a long weekend, you can use that information to assist with respect to whether those people are engaging in culpable absenteeism. And remember, culpable means blameworthy, which means discipline can be the result. So there's two duties for an employee. They are to attend, and if they can't attend, they're to notify and provide information as to supporting their absence. When it comes to identifying culpable behavior, the onus is on management. Supervisor responsibility, management responsibility. It comes in two forms, not only in respect of tracking, but really it comes into how much do you empower your supervisors to make those decisions. You've got the perfect employee who shows up late once for the first time in 5 years. Do you come down hard on that employee or not? The other chronic people, have your supervisors identify that so you can track those culpable absences so that you can be on the ball when it comes to progressive discipline. Consistency is the real importance, but don't be dogmatic with respect to consistency. It has to be reflective of sometimes individual behavior as well. It's good to have these rules and regulations down. So not only do your employees know it, but management knows how to approach these crucial issues, because it is going to come with some personal experience and some personal excuse, and you want to empower management as to how to deal with that. Strict standards are important because it puts everyone on a level playing field, and that way it provides you with some guidance. When it comes to culpable behavior, you've got to have that background because you want to engage in progressive discipline. Where you're talking about blameworthy conduct, the process always has to follow through with respect to how discipline is related to the actual malfeasance and errors that are happening. So you start with oral, verbal warnings, written warnings, potential transfer or demotion. If the person can't work at this level, then maybe the person is in the wrong position. Now, you've got to be careful about permanent demotion. You don't want to engage in constructive dismissal or termination cases involving permanent demotion when you're dealing with unionized environments. But for a temporary period of time, particularly if it's going to be also brought in with other performance management review, temporary demotions can be effective. Ultimately, you get to suspension and discharge for cause, just like in any other progressive discipline case where the person starts to refuse to use the process and respect the process. That's the culpable behavior. Megan's going to take us through non-culpable or innocent absenteeism.
And just one thing before Megan goes through that, Michael, it's a good point. Culpable behavior is blameworthy. It is disciplinable conduct. All right, but we don't know all the time what we don't know, so we can ask the questions. I think Michael focused on that. You have the right to ask the questions. All right, don't be afraid to do so. Do so, though, in a consistent and kind of formal way and a pattern in which you treat all employees the same. Megan?
Thanks, Lorenzo. So non-culpable or innocent absenteeism. This is an absence that is justified, such as for medical reasons like illnesses or an appointment, an injury. The worker may be injured outside the workplace or on the job. Other personal reasons such as bereavement, emergencies. You've got other absences like jury duty, subpoenas where someone's ordered by a court to attend. And then all of the gamut of permitted leaves under the Employment Standards Act, such as maternity, parental, and family leaves. So how do you deal with these types of absences, non-culpable? Well, you can't discipline if it's a result of one of these non-culpable grounds. As Lorenzo was saying, you really do need to drill into the reason that the employee is not there. And if it's for one of these justified reasons, you really do need to consider alternatives to how to manage that absenteeism. So this can include performance improvement initiatives, coaching and discussions, and accommodation. Now, accommodation, we're going to get to in further detail in this presentation, but it really is a two-way street and a dialogue between the employer and the employee to understand what their needs are. And there can be a host of reasons. You see here a few: physical or mental disability, caregiver obligations, and some family status duties and responsibilities. So remember that these types of absenteeisms can't result in discipline or termination. There is, we'll obviously get to as well, frustration of contract and when excessive absenteeism leads to this, but that's something to be aware of when looking and tracking your employees' absences. So how to manage this? As we've said, tracking, document it. You want to know the statistics for all your employees in the workplace so that you can have goal setting, so that you can have statistics, that you can understand what reasonable absences are, what your numbers are in the workplace. Now, you do have to be careful in asking too many questions. You still, as Lorenzo and Michael have said, you're still entitled to ask for a reason why they're not in the office that day. Ask for documentations to support it. Have a uniform way of addressing it and deal with that in each case.
So how many of you this morning on the way into work listened to commercials on the radio that talk about the disability lawyers who can sue their employers when they ask questions about whether or not they're coming into work when they have a legitimate disability? They're all over the radio. They're all over print media. They're all over the internet. That's where the two issues intersect. Even if there is a legitimate issue with respect to an absence, the employer still has the right to figure out, because they're under an obligation to accommodate, what the restrictions are, if they can come back to work, and all of that. But those intersect. And what we're finding more and more, and my colleagues here can speak to this as well, is that any request for information, now we're getting that refusal to provide medical because there's a disagreement with the insurer, or a denial, or the fact that they don't believe you have the right to ask. That's where it gets difficult, all right? So we're going to take you through a little bit of that later on in the presentation. So accommodation and statutory rights. Why is accommodation important? Well, because people who are off work for legitimate causes need to be accommodated to the point of undue hardship. There's the legislation. There are all kinds of different pieces of legislation which import the obligation to accommodate. And in almost every civil suit we get right now that has to do with a person who's been terminated as a result of some kind of absence, these are referred to in one way or the other, and in particular the Human Rights Code. The Workplace Safety and Insurance Act has a reinstatement obligation, which is rarely actually a reinstatement, but involves penalties to employers in the event that there's a termination following a period of injury, which is approved under the WSIA. And the reinstatement obligation kicks in if there's an inability to work due to a work-related injury. There's employment for 1 year at the date of the injury, and the obligation is you've got to put them to their pre-leave job or a suitable alternative, which is often a very difficult thing. I will say most employers usually have fairly complex return, particularly those that are unionized, complex return to work procedures when it comes to accommodation for WSIA injuries. Where it gets a bit more difficult is those non-work related injuries, and sometimes those aren't nearly as sophisticated. The obligation under the WSIA on the obligation to reemploy is the earlier of 2 years after the date of injury, 1 year after the notification by the WSIB that the employer is able to perform the essential duties of the job. That's an important one to get. or the 65th birthday, or up to 67 if there's a later injury. That doesn't end your obligation to accommodate. That is under that legislation where there's a workplace injury. The general duty to accommodate, as we know and we've done many presentations on, exists under the human rights legislation for injured employees. So we're going to get into the code, which Mike will speak on now.
So with respect to the code, it specifically prohibits discrimination in employment, and this applies to both existing employees and applicants for employment. The applicants for employment issue is also covered by the AODA, the Accommodation for Ontarians with Disabilities Act, where there's specific requirements in respect of job posting, job advertising, saying that you have to make applicants aware of the fact that they have a right to accommodation. So your issue with respect to potential disability accommodation or absenteeism issues is right front and center, even with applicants for employment. And the key protective grounds of the code that usually come up in these situations are age, disability, family status, and marital status. This is all dealing with kids, parents, and quite frankly, when we're looking, as Lorenzo took us through the WSIA obligations, what happens with employees as they get older, particularly past age 60, 65, where some chronic issues, some to come to the fore. You cannot use that as a distinguishing factor to say, well, we're no longer going to accommodate this individual because, well, the chronic issues are just getting too much because they're 67 years old. Accommodation itself is a multi-party exercise. It includes management, employees, and the union if there is one. This is very important because it's management, human resources supervision, working with the employee who has the access to their own medical. You have, as Lorenzo pointed out, you as management have the right as part of your accommodation duties and obligations not to see the diagnosis of the medical in most cases. We'll talk about mental issues a little bit later where the issue of diagnosis sometimes comes to the fore. But you're entitled to see confirmation and prognosis. What are their limitations? How can that be accommodated? What's the expectation duration of those limitations so you can bring them back to work? You are entitled to see that as part of your accommodation process, irrespective of whether it's being analyzed by LTD, insurance provider, or the WSIA, because you're involved in your own direct obligation to bring them back and try to bring them back to the workplace. Last year, we saw a lot of upheaval with respect to the Employment Standards Act, and they did bring in significant changes, or at least at the end of the year, splitting up what used to be called emergency leave into basically a bunch of separate grounds. So the ESA has done always what it always sort of originally did, which is it provides certain unpaid time off of work in specific circumstances. Again, in each of these circumstances, the obligation under the legislation is that the employee has to provide reasonable information, sometimes actually spelled out information, for example, family responsibility leave or bereavement leave, where you actually do have to provide doctor's information, doctor's notification as to the seriousness of the medical condition of the individual who is suffering, so that the employee can have the time off. These are permitted leaves that are reviewed and added to regularly. We don't see many taken away. We do see them often added to. So it's something that you have to keep on top of with respect to human resources. These are job protected leaves, which means employers cannot threaten, fire, or penalize in any other way an employee who takes or plans on taking personal leave, and they're entitled to return to their position or a comparable position if the prior position no longer exists or duties performed. Key here again is you can't penalize. So when we're talking about attendance management, effectively these ones don't count. You've got to structure your attendance management program so that it kicks in afterwards. Now, there is some gray area with respect to counseling, because you can counsel people. That's not disciplinary. How can we help you? How can we get to understand what your restrictions are? So maybe we can put in plans to help you attend regularly, but you cannot penalize, which really means that these days don't count to attendance management program. And then when we're talking about return to work, it's not just a position, it's if the duties are there. So if the duties are still being performed, you've got a high bar to cross to say that the individual shouldn't be returned to work. What we're getting a lot, and I've got a few questions on this, is what about extensions? Extensions are only allowed with respect to the extent of the duration of the leave under the Act. Once you're beyond the restrictions of the Act, it's up to you as management. Do you want to extend that leave or not? And if you do, it's not necessarily protected return. The employee may have to take a risk that the individual cannot return after that. Now, again, that still potentially brings in the notice and severance issues when they ultimately say they're not returning to work, but you don't have to extend leave. It can be something that's up to you. The protected leave is only as spelled out in the statute.
And one question that we often get when we get, we'll get calls saying this person has been off this many days, they've been off on leave, and the issue becomes, well, did they invoke their statutory leave under the Employment Standards Act for those days in which they've been counted? In many cases, Michael, they haven't. Right? And then the question is, do they count or not? Because they haven't invoked. Did you ask for medical at the time? That is a little bit of a gray area too, and you got to be a little bit careful when you're dealing with that.
Exactly.
Okay.
So when it comes to the changes, Bill 47, all of these days, remember now, they're all unpaid. If your own policies or your collective agreements required paid time off, you're essentially at this point greater than the Employment Standards Act. You still get into some counting and some ordering issues, but as previously, this is less of a concern because employees typically don't want to take unpaid time off. Sometimes that does happen, but for the most part, it's usually not a concern for most employers under their policies. So the double counting issue is also sort of now waned with this return to unpaid days. So you've got sick leave, three unpaid days, three unpaid days for family responsibility leave, which is sort of similar to the old emergency leave, and then you've got 2 unpaid days specifically for bereavement. Again, as we indicated beforehand, we're talking about leaves are getting added to. So one of the additions to the ESA, which was not changed, was the addition of domestic and sexual violence leave. The first 5 leaves taken in the calendar year are paid. This is a calendar year process, and the rest are unpaid. So it's an interesting little double counting situation, and I think that's reflective of the fact that when you're involved in domestic and sexual violence issues with one of your employees, it is going to be a fits and starts situation. Clearly, the first issue is going to be getting to safety, and then the second issue is going to be getting into a routine or potential as much as possible routine. So that's why you've got this sort of different, a more flexible process, because oftentimes it is accompanied with trying to get the domestic order and situation and basically get people safe first.
Megan?
Thanks. Yeah, I mean, so these new leaves are under Bill 47, the Conservative government's bill. We've done a lot of presentations and had a lot of questions about the old leaves under 148 Bill 148 that the Liberal government had brought in. But in this case, what is in place now by the Conservative government is Bill 47. So the new leaves that Michael's just set out are, as he set out, the 3 days, 3 days, and 2 days. These are not paid, and for these types of leaves, they do commence after 2 consecutive weeks of employment. The other leaves continue after 3 months of employment to qualify. And, employees can't pick and just say, I'm going to take a half day off to deal with this. If the employer so chooses, they can deem the day to be an entire day off, whether or not the employee is there for the morning or not. The employers can also, now under the legislation, ask for reasonable evidence, including a doctor's note from the employee.
All right. So now that we're identifying and recording both absences, let's deal with recording non-culpable absenteeism. And that's a more difficult thing because employers are generally a little bit more reticent of asking for information when it comes to somebody's legitimate or health-related absenteeism. And that includes both physical and mental health. So that's going to be an issue that we're going to have to struggle with throughout when we're dealing with mental health issues, because oftentimes the information that you're getting, or the person who you're asking to get the information, which is the employee, and you're not dealing directly with the doctor, it can be difficult to get that information. But you do have the right to request medical evidence and in support of not only the absence and the projected return to work date, but also the restrictions on the return. That information should be specific to the job duties of the individual. I cannot tell you how many times we get questions where they're saying, well, the doctor just gave us a general note. We don't even think the doctor knows what this person does. That information should be specific with the knowledge by the doctor, provided by the employee, but give them job descriptions, we often tell them, to take to the doctor to say, this is what they do for a living. All right, we need your medical note to be consistent and representative and relate to those duties rather than just they're off. So we can ask those specifics. You have to have kind of a triage on assessing those personal excuses. If people are actually away and there's a pattern which would, for example, demonstrate a certain pattern of mental illness, you may have to ask for more information or come to some conclusions or have constructive knowledge of the fact that there may be a mental health issue. Records, as Megan indicated earlier on, very important to keep records. All right. What we find in most cases that employers where they fall down, if there's a problem, is the fact that they haven't tracked this properly. So something as simple as tracking absenteeism, what's been going on, that's very important. Surveillance, we get a lot of questions about surveillance. It might be appropriate in certain circumstances if you think that there's fraud involved. But remember, a lot of the time you're going to be in a situation where the medical might be in support of if somebody's on vacation, for example. They might say, the doctor might say, well, that was something that I prescribed as a result of the fact that they were dealing with stress. So I think that's something that you have to actually think about. It's also very expensive, but it might be appropriate in the right circumstances. And it may be, it's management's responsibility, but at some point, if there's a refusal to provide information, it could turn into culpable absenteeism. That's an important distinction because it's a refusal to provide information or report to work as instructed. So that is really a primer on how to identify it, how to manage it. It's a lot harder than it looks, but it does require vigilance and it requires kind of appropriate documentation to build the file as if somebody's down the road is looking at it and saying, what did you do right? What did you do wrong? So on that point, we're going to look a little bit at attendance policies, and Michael's going to deal with proper drafting. Oh, sorry, there's another one here. A response to non-culpable absenteeism. I'll deal with that. It's counseling, and again, this is even in unionized settings. It is not disciplinary in the sense that it's counseling. So you sit the person down and say, we've noticed that you've been off work a lot. Here are the issues. We want to assist you in coming back to work on a regular basis. What can we do? It can be oral. It can then be written. Frustration is a big issue. We'll talk about that in the case law. We're getting a lot of questions right now. Well, why can't we simply say that the employment is frustrated and give them their termination pay and severance pay? Because the courts have said that you've got to be patient on this. The Human Rights Tribunal has said you've got to be patient on this. All right? So remember that in a frustration situation, you still have to pay ESA. All right? But if you can get away with that, often that's the best result. And then follow your statutory requirements. You must accommodate to the point of undue hardship. There is no end run around that responsibility. If the employee is refusing to participate, that's a different issue. That turns to culpable. But your accommodation responsibility remains. Michael?
When it comes to drafting attendance management policies, and I've taken a look at some of the questions that have come in. The first question you may want to ask yourself as a workplace is, do you need one? And when you think that you need one or want one or believe you need one, then the next issue has to be, have you tracked absenteeism and do you know what your rate is? How are you going to make any of the other steps in an absenteeism program without the essential data? For example, your policy in your workplace allows for 4 or 5 days off with pay, and your absenteeism rate turns out to be 3.5 days per year on an average basis. Do you actually have an absenteeism problem? Do you have something to address? And how will you know if employees are over or above that if you don't track the numbers? So step one, get the numbers. And it may take some time, but understand the numbers in your workplace. Because that's the first step of obtaining an effective tool, because you have to make that management policy known to employees and you have to see that it's explained and then consistently enforced. So an attendance management policy is just part of a larger attendance management program, both the benefit and the downside, and as well as making sure that you're keeping separate culpable and non-culpable absences so that you're progressively disciplining or counseling those. Have a program of follow-up. You should have a statement of attendance expectations. What is your philosophy with respect to sick leave? There's going to be, sometimes a workplace is going to be, we are focused on 100% attendance. Other workplaces are going to be, if you're sick, please don't come into work. You have this benefit, use it, take it. You want to have that as your guiding principle, because you know your employees are going to catch you out. If your policy says, we don't mind that we actually expect that when you're sick, you're not going to be in attendance. We understand work-life balance. And then all of a sudden on day 5, they're inside a counseling interview as to why their absenteeism is becoming to be excessive. Reporting procedures are important because that provides you with the raw data and also provides you with a tracking mechanism so that you can know the reasons, understand the reasons, and even when individuals become the focus of your employment policy approach, then you know exactly why they've been off. It could be that they are on a chronic basis, but the chronic basis may all have explanation. Flu, broken leg, mother sick. Everyone knows this, and yes, it turns out to be bad numbers for that employee, but nothing anywhere close to being culpable or even, quite frankly, non-culpable. Medical certificates, have that in your policy so everyone knows. You want to obtain information from qualified medical practitioners and also put the onus on employees. It's not always going to be a GP situation. For example, in mental illness situations, a diagnosis of depression from a GP is not going to carry as much weight as a psychiatrist or a psychologist who may have better understanding as to what accommodation entails. So keep in mind any terms in your collective agreement. Oftentimes, and we see this a lot, is who has to pay for this? Well, oftentimes it can be paid for under the process of your insurance policy, but ultimately you're going to have to make the call. How important is it to you? There may be a time where reasonableness of requesting medical documentation also requires employers to pay for it. So asking for the doctor's note for every person, for every illness and every absenteeism may be excessive and unreasonableness, but once an employee maybe triggers some additional absenteeism rates, you advise that employee that they now have to provide reasonable information, and that includes paying for their own note. When it comes to discipline, set it out. What is going to be the disciplinary process? What is going to be the review process, and ultimately what's going to be the result? In order to terminate on the progressive discipline process, you've got to advise the employee that termination is going to result. It can't be up to and including discipline, including discharge on every letter. Ultimately, you're going to have to advise the employee under the policy that the next time is going to lead to your termination. The employee needs to know that. Finally, on this sort of attendance policy, we get sometimes questions with respect to attendance rewards. That, again, should be driven by your overall employer policy and what kind of expectations do you have. Clearly, if you're going to promote attendance, you're going to have employees who are going to be attending work when they're sick, or you're going to have employees who feel that they must attend even though they should otherwise be off. So it really comes down to company philosophy. The rewards typically are not big issues. Sometimes they're just recognition. Sometimes there are gift cards. They're not substantial. You want to also keep in mind tax consequences for employees. You don't want to say, we're going to give you a big screen TV, and oh, by the way, it's going to be a taxable benefit. So that big screen TV, which you won, now is going to cost them $300 on their taxes. So you have to be careful of that. And clearly, you've got to be careful of unionized environments, because the union sees that as negotiating directly against an entitled benefit. And they could be a hindrance to introducing these kinds of rewards. So really, while attendance management programs themselves have to be reasonable to be enforced, they are accepted as being so by courts and by arbitrators.
Thanks, Michael. Megan?
Thanks. So attendance management programs, big picture, what's the point of them? They really assist employees in achieving regular and improved attendance at work. That's the goal here, is to help you as a company have regular, productive people in the workplace. This is also aims to manage absenteeism using a consistent approach. We often hear from clients and employers who notice, this one person is always off, but they don't have a consistent approach to tracking and documenting all of their employees. So they really can't tell us how abnormal this is, how big an issue it is, and therefore they're constrained in actually dealing and addressing with the issue. As Michael mentioned, the purpose of these programs is really to help deal with both culpable and non-culpable. Culpable through positive intervention, culpable attendance issues through progressive discipline. Now, most programs establish triggers or thresholds for actually entering into the program. And as Michael mentioned, this has to be within the permitted statutory absences in Ontario. So for example, it shouldn't include the first 6 or 8 days of absence due to the protected leaves under the Act. They should also be able to compare employees' absences with the company average and company goals. As we've been saying throughout this presentation, tracking is huge. Tracking is really important and will help you deal and manage your employees. As we said before, you need to also differentiate between culpable and non-culpable absences. Culpable, you deal with through progressive disciplinary measures, non-culpable through counseling, case review, and documentation. As well, as we've been saying throughout this, deal with accommodation at each step of the process. Ask and discuss what is needed to help employees achieve regular and consistent attendance. Now, some limits with these, a policy cannot use absences caused by disabilities to negatively affect the employee unless there's of such a huge extent and duration that they would constitute undue hardship, a concept that we'll get to later in this presentation. Attendance expectations should be clearly outlined at the beginning of the policy, and the policy should expressly define what types of absences are considered culpable and non-culpable.
Thanks, Megan. And so just to pick up that point on limitations, and Michael and Megan have both mentioned points of this earlier on. So make sure that statutory leaves are not included in that disciplinary response. They're not caught by the policy. And the test under collective agreements for years when it comes to what we call innocent absenteeism is that the absenteeism is excessive and there's no reasonable prospect of improvement for the future. That's frustration of contract. But under a collective agreement, it actually switches the onus to the employee to show once you prove the absenteeism issue, which is non-statutory, then it switches the onus to the employee to prove that they are capable of reasonable attendance in the future, and that's an important distinction. Frustration of contract, again, not a catch-all. It's very specific. We're going to talk about that. More limitations. Be creative. Don't be restrictive when you're looking at targets, but also make sure that you understand you're comparing apples to apples when it comes to attendance. If you're saying to somebody that they're using their numbers for innocent absenteeism or non-culpable, and you're including short-term and long-term leave disability, that needs to be compared to all similar numbers across the organization if you're using that number as a comparator, all right? Respect confidentiality. That's always an important part of these policies. And be aware both that law and practically that termination is going to be a last result. All right. Now, if this is a union environment, it changes a little bit. The union needs to be involved. If there's an accommodation issue with respect to that absenteeism or return to work, make sure the union is involved. Put the pressure on them to participate in the accommodation. That's very, very important. Unions don't get off scot-free. So when we're going to look a little bit now on culpable absenteeism case law, and we'll start, Michael, with the TELUS decision.
This is an interesting case. Sort of happens probably more often than most employers want to admit. So in this case, there was an employee who was denied a request to have a day off to play in a slow pitch tournament. So right away, you're starting off sort of in a combative situation where an employee has requested time off and is being told no. Good management tip: if you're telling the employee no, oftentimes it's best to give them a reason as to why. Maybe this person is occupying a position. Maybe it's an important time in the work cycle. At least give some advice and information. Have the option potentially of even using a vacation day instead. But in any event, we're into it. The employee's been told no, and then on the morning of the tournament before the start of the shift, the employee has texted the manager saying he can't attend for unforeseen circumstances. Manager went to the ballpark, saw the employee pitching in the baseball game. And probably more importantly, this is sort of where the case got off the rails for the employee. So at a subsequent investigation meeting, clearly the manager has seen the employee on his sick day playing in a tournament. And when questioned, the employee got defensive, stating that, yes, he was in fact sick, but his symptoms would prevented him from working, but not prevented him from going to the park. He then asserted that he was just there to watch and not to play. but somehow the circumstances changed and he ended up pitching, but he was not batting. Not sure what the difference is there. Ultimately, the employee was dismissed and the employee's union grieved the termination. At arbitration, the arbitrator didn't see sufficient reasons to conclude that trust could not be reestablished if the employee was reinstated. So clearly this was maybe as much of a question of lying than anything else with respect to the whole sordid situation. And the arbitrator reinstated him, but with a 1-month suspension put in place at termination. As a side note, always important in these cases, particularly in unionized environments, to consider how serious you want to hit the employee with respect to a penalty. Not all breaches of policy are going to lead to termination. Sometimes you can send a message with a severe penalty that's something short of termination. It was appealed, and ultimately both the court and the Court of Appeal in Alberta upheld essentially the termination decision, or at least said that the arbitrator's decision for finding that it should have been replaced with a 1-month suspension was unreasonable. The conclusion was primarily drawn on the fact that it wasn't up to the employer to prove that the employee was sick or that there was any basis for the employee taking the position that he had this condition that prevented him from attending at work. The focus was on the fact that there was a changing story and that the employee kept on shifting his position during the interview. And essentially it came down to he lied, he got terminated as a result. Courts typically and arbitrators usually will not tolerate people who lie. So this could have been a different result if the employee had come clean. And it also serves as a caution that if the employee ultimately comes clean and says, yes, I'm sorry, I really wanted to go, and you said no, that may have been sufficient to have actually not resulted in termination. Maybe serious discipline, but not termination. Always, if you expect your employees to ultimately, come around, you got to give them sometimes the benefit of the doubt on termination decisions.
So before we get into non-culpable absenteeism, I want to go back a couple slides to the Hydro-Quebec, because we're going to get into frustration of contract. And this was an important case back by the Supreme Court of Canada back in 2008, because there's always an issue as to how long is enough. And the law shifts on that. And we get questions like that all the time. Is it the 2-year ENIAC if they're on or ONOC under disability policies? But what the Supreme Court of Canada said with respect, and this is a very long case, important case by the Supreme Court, where an employee was out 3 of 7.5 years they were out. So about 40% of their working life, they were not at work as a result of a legitimate disability. But what the court said is they said the test isn't impossibility. So it's not whether it was impossible for the employer to accommodate. All right. The employer doesn't have a duty to change working conditions in a fundamental way, but if it can do so without undue hardship, to arrange the workplace to enable the employee to do his or her work. That is a very good way to remember the test for undue hardship. Recalling, too, though, that it is still a very high test. No matter what we read, it's still a very hard test. But it's not impossibility, which is what many unions, for example, will assert when you get to a termination arbitration on this basis. Megan, the Roscaft case?
Thanks, Lorenzo. This is a recent Ontario decision of 2018, and it's a good precedent for employers. In this case, an employee of over 13 years went on long-term disability in 2012. He was off for over 3 years, and finally in September of 2015, the employer terminated his employment for frustration of contract. So on termination, the employer continued under its plan the employee's LTD benefits, provided that he remained totally disabled as defined under his insurance plan, and paid out the minimum ESA entitlements. So in Ontario, that would be any termination pay and severance pay that the employee was entitled to by law. Now, Rona, the employer, brought a motion for summary judgment in response to the plaintiff's claim. The plaintiff had claimed for wrongful dismissal, saying he shouldn't have been terminated. Rona moved for summary judgment. And at that court attendance, the plaintiff alleged that when he was terminated, he was actually starting to feel better. And if only Rona had reached out to him and made some inquiries, they would have learned that before they made their decision to terminate. Now, Rona took the position that at the time of the termination, neither the employee nor Sun Life had provided any information that showed that there was any kind of change in the employee's status or that there was any likelihood that he was soon to return to work. So the court actually dismissed the plaintiff's claim, and there's a good quote here. I won't read it in total, but Justice Pollack found that it was reasonable for Rona to conclude in those circumstances that there was no likelihood of the employee returning to work within a reasonable time. So in this case, the judge dismissed the employee's claim for wrongful dismissal damages and held that the employer actually had enough information in front of it to make this decision.
And that's very important because a lot of plaintiff lawyers in particular took the position that there was this independent duty to inquire all the time prior to invoking the concept of frustration. We still think it's good practice to ask that in many cases, particularly when we get employers come to us and say, we have all these people who are on LTD for a long period of time, and we just want to terminate them all and give them their employment standards, right? That's an issue where I think the duty to inquire does come in, and there's a distinction, but this is very helpful to employers.
This case is very helpful, but you cannot get over the hurdle of if the judge asked you what form of accommodation and what led you to the conclusion that you couldn't bring the person back to the workplace with this condition. You have to then, it's up to the employer to prove that, and you'd have to prove that you did try to accommodate. And you can only do that with doing an independent analysis with respect to your review, your employer, the company's review of the person's restrictions and what jobs were and were not available.
So that's the frustration issue. We want to touch base, and we're going to touch on our next seminar, in particular webinar, on family status and accommodation. But this was the Mystic case, very famous case that came out in 2016. And this was the HRTO decision where the applicant said, there was a change to my work schedule, or proposed change, and that it discriminated against her on the basis that she had elder care responsibilities, which is a big deal these days, and she needed to be home in time to prepare dinner for her mother. So the tribunal said, look, Mystic failed to make out the case of discrimination. She hadn't provided the appropriate information, which would allow the employer to make the appropriate determination as to accommodation. That goes back to what we've been saying all along. We're going to talk a little bit about the varying tests of family status accommodation, but the bottom line is you're entitled to that information so you know how to accommodate. All right? And you'll see the quote there that talks about the fact that the ability to provide evening meals was not adversely affected by the requirement to work days, evenings, and weekends. This case is as much of a case of a person who didn't provide the appropriate information as anything else. So the tribunal, the commentary in this case really is that even though the tribunal said, we're going to move away from the Johnston case, which was a federal court of appeal case for family status discrimination, which determined that the child care obligation issue must engage the individual's legal responsibility for the child, and that was difficult to apply in the context of elder care and could result in a higher test for the purposes of accommodation and child care. But the bottom line is, really good lesson from here is you got to ask for the information properly, consistently, and if you do and you don't get it, you might have a defense. Megan?
I think the really key piece of, the factor in this case was that the employee was able to provide lunch for her mom when she was away from home. She would leave a lunch for her mother. And the argument was, well, why can't you do that at dinner? You've given no explanation as why you're able to provide lunch when you're away from work, why you couldn't do the same with an evening meal. So she wasn't able to provide any information to her employer for her rationale, and the court saw through that.
Perfect. Thank you. So a few conclusions, and we know we've gone through a lot of information, but we wanted to leave about 10 minutes for questions, and we have a lot of questions. So always consider the relevant statutory context. If it's protected leave, you can't discipline on that basis. That's very clear with both union and non-union environments. Make sure that you have a policy. All right, they are effective tools to manage absenteeism. But you got to be consistent, you got to track, you got to use the policy. All right, very important. Track. Make sure that you've got the information on absenteeism. It's consistent, you're comparing apples to apples. All right, and that in kind of 3 bullet points